Welcome to the Peaceful Presence Divorce Coaching Lunch and Learn series. My name is Kat Climaco. I am the founder and owner of Peaceful Presence Divorce Coaching. This is the second event in our Lunch and Learn series, and we're going to hear from experts from a ton of different fields who have generously donated their time and their wisdom to help us rebuild, heal, and navigate throughout this journey. Our wonderful moderator, Shruti, will be keeping an eye on the chat, and she'll make sure that your questions are shared with us during the Q&A portion toward the end. So just one more quick reminder that today's session is being recorded for those who couldn't join live. So with that, let's go ahead and get started. I am thrilled to introduce our guest speakers today, Cierra Garzo and Hannah Schroinger. Cierra is a family law attorney with a dedicated experience helping parents navigate complex custody matters. And Hannah Schroinger is an LLP whose background is deeply rooted in supporting survivors of domestic violence through the legal system. And together they've helped countless parents build parenting plans that close loopholes, reduce opportunities for manipulation, and make expectations crystal clear. So today's topic is something that is one of the most important topics that I work on with my private coaching clients: how to protect your peace by drafting manipulation-proof parenting plans. So let's dive in. Cierra and Hannah, I'm so thrilled to have you both here. Even the title reminds us that a parenting plan is more than just an administrative document. Why don't you start by letting us know what was the inspiration that drove you to focus on creating this topic of discussion for us today?
Yeah, and thank you so much, Kat. Cierra Garzo here. Just wanted to, again, thank you for hosting this. Thank you to everyone who is taking the time out of their day to be with us here live or to watch this recording. Yes, and we're looking forward to speaking about drafting a manipulation-proof parenting plan. Oh, and I wanted to give a quick disclaimer that I am an attorney, but I'm not your attorney. And same goes for Hannah as an LLP, that no legal counsel client relationship is being formed through this webinar, but we're excited to share our experience and wisdom with you all. From my perspective as a lawyer who deals a lot with contracts, this is sort of, contracts 101 is making sure that everyone is very clear on the terms and that we know what happens if someone violates the terms. So my experience dealing with the law, dealing with contracts really lends itself to creating documents like this, which, for better or worse, the average person just isn't going to have that background, and they may not have the same set of experiences that lend itself to creating terms that won't be busted by a high conflict or narcissistic co-parent. And then I will kind of pass the mic to Hannah to give her perspective on, why these plans are important.
Yeah, absolutely. We chose to chat about this topic because it is one of the big bread and butter pieces of a divorce with children. And so often you see parties who think they get along or want to get along, and so they think that once the divorce is final, all of the tension and issues go away. And after many years of practice, we, as the professionals in the situation, know that that is more than likely not the case. And so we take it upon ourselves to really advise our clients, no, let's take a beat and let's just think about this, because, and we'll chat about this more, but giving concessions for future scenarios almost never ends well and kind of punts the conflict for down the road. And creating an airtight or manipulation-proof parenting plan helps solidify details so there's no questions, and it helps reduce the every parenting exchange back and forth that can happen when the parenting plan is not specific.
Yeah, I love that you bring up even for low conflict couples that it's really good still to have sort of an airtight parenting plan because you can always be more flexible later, but you can't build in more structure after the fact. So, yeah, that's great insight.
Yes. Okay. And just for those low conflict folks, we don't want to leave you out, but things like putting in the upon mutual agreement, but if no agreement can be reached, this is your plan.
Mm-hmm.
So we're going to be talking mostly about folks who are not going to succeed at the upon mutual agreement at all. But, even if you do think that you're low conflict, this still can apply to you. You can use this backup language. Okay. So I'm going to tell you just a little bit more about my practice. I've been an attorney for about a decade. I've practiced family law pretty much exclusively ever since I got out of law school. So I've had the opportunity to work under some of the brightest legal minds in the Denver Metro. And through those experiences, I've seen just about, every situation that you can think of. But since I'm an attorney, I can create in my mind about 100 different more because that's what our brains do. And that is really helpful when we're creating airtight parenting plans. And then Miss Hannah, I'll let you speak a little bit about your background.
Yeah, I've been in the family law industry for about 9 years. I started all of my career, professional and legal career in family law. I started off as a family law paralegal, and got my license as an LLP, a licensed legal paraprofessional, June of last year. And I have always gravitated towards providing legal assistance for survivors of domestic violence. And as a survivor myself, it's always been my call to action, I feel like. And so I really love having my legal license and being able to provide legal support to the underserved community. And as an LLP, I have a little bit more community reach. Some people hear law firm and attorney and get really freaked out, or as an LLP, my hourly rate is reduced from an attorney's, and so I'm able to help serve the community with lower cost legal services as well.
Yeah, and Hannah and I are the co-owners of the Jane Law Group, and part of our mission is to bridge that access to justice gap and make sure that people of all income brackets can receive legal support and legal counsel through these difficult situations. So our firm can provide sort of a wide range of services. And we can talk a little bit more about that later on, but I think everybody's here to kind of learn about some tips, tricks, ideas, strategies to make their parenting plans airtight. So I'm gonna move forward and we'll talk a little bit about, we want this to be very technically valuable for you guys. So we're trying to include as many real world scenarios and ideas as possible. I'm going to take a couple of these and Hannah will take the other two. But when you're drafting a parenting plan, I guess I'll also just remind everyone that when we're drafting our parenting plans, this parenting plan is either going to be agreed upon by both parties through negotiation. And when you have a high conflict person on the other side, these negotiations may be quite challenging, and they might go on for a very long time. But if you can give that other person something that they want or something of value, you might be able to get an agreement. Probably not because they are reasonable or they see the wisdom in this or that it's the best thing for their kids, but sometimes you can give them something they want in exchange for this type of agreement. So you're either taking your parenting plan and getting it signed by both parties and submitting it to your court for approval, or you're preparing this parenting plan to present to the judge or judicial officer in the court where your case is, and you're asking them to adopt the parenting plan that you have drafted. Because if you leave it up to the judicial officer, they are very time strapped. They are not going to include all of this wonderful detailed language for you without being very specifically asked. So this typically happens when you're presenting a drafted parenting plan to the judicial officer for them to adopt at the end of litigation. So those are the two ways that this parenting plan can become an order of the court. Okay. When you're drafting this document, I'm going to talk about making it future-proof and avoiding giving away more control than absolutely necessary. So when I say future-proof, you may be tempted in some scenarios to say, like Hannah was saying, let's punt this essentially, and we'll just put, we can't reach an agreement, let's just put upon mutual agreement of the parties. And then we don't have to deal with that right now. We'll get our agreement signed and we can move on. Well, down the road, that might come back to bite you when you cannot reach an agreement. And you have to then turn to the court or an arbitrator to help you reach a resolution on that particular decision. So we suggest not banking on the idea on the other party's goodwill that you'll be able to reach an agreement at a later time. Include the specific language now. And if you need to soften it up, you can say upon mutual agreement of the parties. If the parties cannot reach an agreement, this is what we will do. So you don't want to be forced to mediate or litigate an issue that you could have locked in at the beginning. Okay. And then as far as avoid giving away more control than necessary, this is a little nuanced. But essentially, you want to avoid any language or term that allows the other party to make the decision. Require mutual decisions whenever possible. Use the word shall instead of may when you want to remove the choice or option, because a high conflict party on the other side might want to latch on to those mays. Oh, well, I don't have to do it. It says I may do it or I'm entitled to do it. Okay, well, a reasonable person would understand that, may exercise parenting time, may do this, may do that. You're going to want to do it. You're going to do it, right? Well, no, we can't make those assumptions when we're dealing with a high conflict party on the other side. If we want to remove the choice in that situation, we use the word shall.
Well, and Cierra,
yes.
just help me. Shall is a legally enforceable term. Isn't that correct?
That's correct.
Yeah.
Shall makes it explicitly clear that this is something that the other party is court ordered to do. Yep. And you can take that with you when you go to try and enforce an order. So that's a great point to bring up. Well, we also might talk briefly about this with something like the right of first refusal. That might sound like a really great term to implement. But when it comes to enforcement, it may end up that the other party is trying to use that against you in a way that you didn't foresee and that you don't want. So it may benefit you to not include something like a right of first refusal if you foresee the other party abusing that. So we'll talk a little bit more about that later. But Hannah, can you give us some info on these other points?
Yeah, absolutely. So some more things to consider is kind of what Cierra touched on, is be as specific as you can. Include times. Parenting time starts at 9 a.m. Anything, if you're late, anything past whatever you agree on, but for example, 15 minutes, we don't have to sit and wait in the parking lot any longer. Creating those carve outs within your parenting plan sounds like so much extra consideration and tedious to do, but it only helps everybody have clear boundaries.
Yeah. And, one of the things I just wanted to say about that too, Hannah, is that that's called, having teeth, putting teeth into our parenting plan. And, I get so many people that reach out to me that say, hey, can you hand me a boilerplate parenting plan? Do you have something you could just give me? And what I always say to them is there's the court boilerplate parenting plan, but that's not manipulation proof. And your co-parent better than anybody else. So if you know that you have a co-parent that is chronically late, and that being late to an exchange is going to be a problem where you're going to be sitting in a parking lot, like you said, waiting, for 20, 30 minutes, putting teeth into the parenting plan. Like if, a parent is late to an exchange by 15 minutes or more, 3 times in a 30-day period, they forgo, the next parenting time. They forgo their parenting time at the next exchange or whatever it is, right? And so knowing who the other party is, and nobody knows your co-parent better than you do, is really key to putting in those contingency plans in the teeth.
Yeah, absolutely. So I love telling clients or advising consults, if then statements are great. And it's not something that the court form even suggests is an option. And that's where the difference in a high conflict case of having counsel or not, or in any capacity, unbundled or full scope representation could really help curate your agreements to reduce that conflict in the future. And then another point in drafting your parenting plan is remember that it applies to both of you. So if it is a statement in the parenting plan that says the parties agree, that applies to both of you. If it says parent 1 shall, that is obviously a designated order for parent 1. If it says parent 2 shall, that is a designated order for parent 2. But if it is a settlement or an agreed upon a stipulated parenting plan, every line item that says the parties agree or doesn't designate that line to one or the other parent, remember that you are obligated to follow that. And that's where Cierra had kind of mentioned that right of first refusal is great for you, but it could also be potentially used against you. And we will get into that in a bit.
Okay. Hannah's going to talk to us, a little bit about some of these topics in creating your parenting plan language.
So in a high conflict case, as specifically, if there has been domestic violence, there is information in the statute that allows the court to order sole decision making for one parent instead of following the standard joint decision making. So
and
when
we're talking about things from a Colorado perspective, you'll want to take a look at or counsel with someone in your state if you're not in Colorado. But sorry, Hannah, I just wanted to throw that caveat out there. That's exactly right for Colorado.
And I just wanted to interject one more thing. I'm so sorry, Hannah, but when we say domestic violence, we're talking about more than just physical violence. We're talking about coercive control. And I think 85% of the states have language in the statutes that designates coercive control. In other words, non-physical intimate partner abuse as a form of domestic violence, which would preclude parties from requiring to jointly make decisions. And so, if you're thinking, well, I was never physically hit or I don't have any police reports, that's not the case. If there's any form of coercive control, manipulation, I won't let our child get therapy unless you do X for me. That's coercive control. That's considered domestic abuse, and it would be grounds to have the victim or target receive sole decision making from the court.
Yeah, I've actually have had consults where it's like, oh well, they've never hit me, and I'm like, pause, let's read into that just a little bit. Domestic violence is not specific to physical abuse. Financial abuse, emotional abuse, mental abuse, all of those things are included when we are speaking about domestic violence. So when you are agreeing or trying to settle your parenting plan with a high conflict person, you can certainly request sole decision making. The likelihood of that being agreed upon is a little bit lower. But like Cierra said, if you are preparing this as a proposed parenting plan to the court, that is something you can request. Sole decision making is when you have the sole choice, you are the only one making these major decisions for the child, including medical, extracurricular, educational, religion, these types of items. What I like to write in a settlement proposal is parent one will have sole decision making after consulting with parent two and considering parent two's position prior to making the decision, because often the high conflict parent isn't actually participating. They just want to feel like they want that right to be preserved because it's theirs.
Yep. And then when you say like parent one shall have sole decision making after consulting parent two, what I really like to do with my private coaching clients is literally build into the parenting plan the specific language. So the proposing parent submits a message, and the other party has 48 hours to respond to that original message. If the parties are not in agreement within 96 hours, the parent, who holds sole decision making can make whatever decision is best for the child, and then, shall inform the other party before moving forward. Literally, like deadlines, because they'll drag it out for 10 months at a time.
Yep, absolutely. And so yes, you can absolutely include that language, and those deadlines can be whatever you want, or maybe they come back with, I don't want 72 hours, I want 96 hours. Great, okay, have your extra 24 hours. I love that for you. Let's do it. And that way it's like they are winning on what they're asking for, but at the end of the day, you still have that sole decision-making piece. And I include this language, and I certainly propose this language in parenting plan negotiations, because you will see this is how the court often orders it when awarding sole decision-making. The court will make it appear as though the parties have joint decision-making, and then at the end of the court's order, it'll say, but parent one gets the ultimate say. And it's like, okay, great. And parties get confused about that. And then if it's your client who has advocated for the sole decision making is like, well, I still have to talk to them. And it's like, you were probably already doing that, right? And so.
Yeah, and Hannah, can I interject on the decision making?
Yeah.
Piece before you go on to the other parts of this slide? From my perspective, sole decision making is I would say the most valuable thing that you can get in your parenting plan. If there is a way for you to get sole decision making, that is worth a lot, because it can potentially remove almost all obligation from conversing or communicating with the other party about the decisions. At the end of the day, you get to decide. That can be the most important thing for your kiddo. If you can't get that, like just straight up sole decision making, I love Hannah's idea. The parties shall make decisions jointly and shall follow the following protocol, blah, 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 blah. But if the parties cannot reach a decision, mother shall make the final say.
Right.
Okay, we're that's pretty good. Like we're happy when we see that. And then if you have to go to court, yes, if there is any trace of something that can be domestic violence, consider domestic violence. There does not need to be a criminal case. There does not need to be a police report. In the state of Colorado, I believe it's by the preponderance of the evidence. So it's just the court needs to find that more likely than not, some kind of domestic violence, physical or not, happened. And we're not going to give these parties joint decision making. So I just wanted to add that, Hannah, before you move on.
Well, and then one other thought too is if you know that religion is really important to your co-parent, but it's not important to you, but the school choice is really important to you, you can have sole decision making on religion. I want sole decision making on education. It's all about pulling levers to offer something they want and get something that's really important to you.
Yeah, absolutely, Kat. That's a great advice. Next is including mental health. More and more, we are seeing issues of children with high conflict parents are recommended to go to therapy. And one parent is saying no. And if you have joint decision making, you have to either address it with the court or the child doesn't get therapy. So in the state of Colorado, a child's age of consent to receive therapy services without their guardian's approval is 12 years old.
That's really important to just know.
Yep, that's just, we're throwing that out there because it's important. So if you have a teenager who needs therapy services, you don't have to wait around for your co-parent to approve of it. The child can essentially sign up and request therapy on their own. Next is considering a PCDM. A PCDM is a parenting coordinator and decision maker. So that's, again, if you really, really just do not want to drag this out, go to hearing for the potential of still getting joint decision making. So you're agreeing to joint decision making, knowing that it's going to just cause all kinds of issues. A PCDM can be appointed to handle those disagreements about major decisions, school choice,
anything you can think of.
Yeah,
anything you don't agree on.
Anything you can think of.
And Hannah, can I just clarify too that PCDM stands for parental coordinator / decision maker, and it's called different things in different states. But essentially, the idea is if a court can appoint a parental coordinator. That means they can say, this is a high conflict case. I'm appointing a parental coordinator to help the parties reach agreements if they cannot. The court cannot appoint a decision maker. The parties have to agree to that. And so, it's something that if you feel like you can't get the other party to give you sole decision making in an important area, you can always say, hey, let's appoint a decision maker. That can keep you out of court, which is great because it's a lot cheaper to stay out of court. But it is important to understand the individual that you're working with. If you have a highly manipulative, very charming co-parent, they can often charm a parental coordinator decision maker. And so it's really important to vet that individual and get references from, other parties. I always recommend you go on to the One Mom's Battle Facebook chapter for your state and throw out the name of a PCDM and say, who's got experience with this person? What was your experience? How did it go?
Yeah.
Because it can be a nightmare. It can be great or it can be a nightmare. It really depends on the person.
And Hannah's going to talk a little bit more about PCDMs in a moment. And then Hannah, and we'll also have a slide on right of first refusal. But
Yeah, and then we'll chat more about considering whether right of first refusal could be beneficial or more detrimental in your case. So moving on, more on the PCDM. A PCDM can be used essentially to break the tie. You have a position, your high conflict co-parent has more than likely the very opposite position, and both of you present your positions to the PCDM, and the PCDM makes that ultimatum for you, essentially. PCDMs have a 2-year appointment limit here in Colorado. But they can be reappointed based on the language in your parenting plan. So you can say in your parenting plan, and this is where it comes back to being specific, the parties agree to appoint person A as their PCDM. In the event, or after the 2-year appointment, the parties agree, if one party wishes to maintain the appointment of person A, the appointment will be renewed. And I actually recently saw that in a case, and I was like, whoever your counsel was had your back, because this is great language.
And we could do a whole webinar on just PCDMs.
Totally. Yeah.
Because they can get really complicated.
Mm-hmm.
On that note, I want to be mindful of your time, ladies. We're at 12:30. I know you have some really amazing points to cover. I wonder, the transportation section that you prepared to me is hugely impactful. Exchanges are one of the most high conflict causing incidents that I notice with my private coaching clients. If you want to I just want to make sure that we cover that one too before we run out of time.
Yeah, absolutely.
Hannah, do you mind if I just skip to right of first refusal for a quick second?
Yeah, go ahead.
Okay. So this is what we're talking about when we say language that you could use when either parent cannot care for the child during their parenting time and then you fill in the blank for the time, then that party must offer the option to care for the child to the other parent before seeking someone else to care for the child. So our mom clients might say, hey, we don't want dad's new girlfriend to watch our kid overnight. So we're going to include this. Boom. We've locked her out. She's not going to do that. Okay. But just know that dad, if you're not specific enough, can turn that back on you and say, well, no grandma sleepovers, no friends sleepovers without me having the first option to care for the child. You know, you're also thinking about sleepaway camps. So if you're going, you can skip this if you think, oh, that's too much. Whatever. I'm not going to deal with that. Or you can include a lot of specific language to make sure that it's used how you want it to be used. And here, let's see. Hannah, you can talk a little bit about like Pat was talking about with that transportation protocols.
Yeah, so like I had said earlier, being specific, include a window of time. Parenting time starts at after school or 4 p.m. if school is not in session. The parent beginning parenting time is responsible for school pickup. So if it's mom's Friday afternoon, mom has to go pick up the kids. Mom can't say, no, dad, you have to go pick up the kids and then bring the kids to me. Dad can't say, mom, you have to come pick up the kids on Sunday morning for your parenting time. Dad needs to drop them off. So you can be as specific as you need for these things. And as Kat was saying, have a 15-minute or 30-minute late window. And if you get the text message at 4:30 saying, hey, I'm running late, nope, your window's already done. You didn't tell me. I do not have to wait for you. And I would include the language, the entire parenting time has been
forfeited.
Yes, forfeited. So you guys aren't rearranging all weekend to try and get a parent their parenting time.
Forfeited, no makeup parenting time. And with all of these terms, we know exactly what's going to happen because we put it in this document. So there's no question. I'm not the bad guy. You're not the bad guy, whatever. It's the paper. Look at the paper. That's what we're looking at. So it takes away a lot of that good guy, bad guy stuff. You can do this with parenting time, beginning and ending. What happens when the kiddo is sick? These are just things you want to take into consideration. What happens if it's a vacation time? Does that change anything about drop-offs, pickups? Who's going to do what? You can even build in, this is the school choice we're going to pick. This is the school district. Or perhaps mom's address will decide the home school for the child. You want to make sure you've included anything you can to remove question or doubt later down the road.
Yeah, and one other thing that I just wanted to interject too, holidays are really challenging. They're very triggering for disordered individuals. And so they have sort of this, if I can't be happy, nobody can mentality. And so the time when they create the most conflict is around holiday exchanges. So putting specifics in holiday parenting time, like on Christmas Eve, the exchange is this time. Specifically, this is the exchange location. This is who drops off. This is who picks up. Just being really, really specific about it is key.
Definitely. Just wanted to mention what happens if you want to change something, or what happens if the other party violates the order. If it is an order and you're in Colorado, you may have the ability to file a motion concerning parenting time disputes. If that's about parenting time issue, that motion protocol has a ton of, the requested relief can include everything from having that other party post a financial bond if they miss parenting time. But just know also there could be, you could be on the hook for paying attorney's fees if the court finds that the other parent didn't violate the parenting plan. You also have emergency motion to restrict if the other party is creating an unsafe environment for the child and you need something to happen immediately. Or a longer term, you could file a motion for contempt, saying that the other party is in contempt of court. A little bit less family law friendly. The motion concerning parenting time disputes is kind of an alternative to the contempt, because those contempt judges, they're civil judges usually. They're not family law friendly. They don't know, they're not looking out for the best interests of the child. They're looking at to whether that person violated the black letter of the law in the order.
Well, and then one other thing I wanted to say about that too, because this is something that I see flying around on social media all the time, where pros A, meaning self-represented parties, give advice to other self-represented parties. Oh, just file a motion for contempt every time, the other party does that. Well, to file a motion contempt, they, for example, if they do something that's not in alignment with your parenting plan, but they have vacated the contempt, meaning they're no longer still doing it or they stopped doing it, you can't file contempt, right? Can you talk a little bit about that? Because I see it all the time on social media, and I understand that you want to hold the offending party accountable, but it's really, really complicated, and it can cost you attorney's fees and make you look like the high conflict individual.
Yeah, so you're kind of touching on this idea between a remedial contempt, or if the party can remedy the thing before the contempt hearing, then they're basically off the hook. They hold the keys to the jail cell. They can get themselves out of trouble by just doing what they're supposed to do. There's another kind of contempt that's not remedial, that's punitive, that says you did this wrong thing, there is no way to remediate it, and you're going to get a punishment. You're going to get a sanction, a monetary fine, some time in jail, perhaps, very unlikely. So these contempts are, in my experience lately, largely, they are symbolic. And you'd probably be better off trying to modify something or do a motion concerning parenting time disputes. If your goal is to punish the other party, unfortunately, family law court is not really the place to do that. It's much more interested in just, what do you want to happen? Like, not punish the other party. What can we do to help your kid? Like, that's what we're focused on as attorneys. If someone comes to us and says, it's not fair, he needs to be punished, it might not be fair. It's probably not fair. He probably should be punished. But can the family law court do that for you? I don't know. I mean, it's probably not going to be the place to do that.
Well, that and you just look like the high conflict individual. If you're trying to make a case that your co-parent is abusive, coercively controlling, not behaving in the best interest of your children, but you're trying to punish them through the court system, they're just going to lump you in as part of the conflict. And so I always, for my private coaching clients say, instead of going that route, let's document. The court won't often make changes based on one-off issues. What they want to see is a pattern of behavior. And so, one of the things that we talk about, Cierra, I know you and I've talked about this, is documentation and creating a record of the patterns of behavior. Because once you can show a pattern of behavior, you have a much stronger position about getting, a modification in parenting time. I actually have a sort of a downloadable guide on how to create your documentation system. Our lovely moderator Shruti just dropped a link to that in the comments if you're interested. But yeah, I think at this point we should probably open up the Q&A. We did have a couple of questions come from the group.
Yeah.
One of the questions that I wanted to highlight is Dana asked, so what happens if the other party doesn't consent to therapy for your 7-year-old child? What do you do? Do you file a motion with the court? Do you fight for full custody or full decision making? I think that's a nuanced answer, but help us understand what you would do before going for sole decision making. Like, what's the remedy there?
Yeah, Hannah, would you want to take that?
I can sure try. So
That's all we can do.
I guess in this scenario, you would need to file a motion with the court on either a motion to modify decision making or
a motion to compel therapy is normally the route. Is
You
that
can
right
try
in
that.
Colorado?
You can do different things.
Yeah.
You can try to get the court to act on that one issue with a motion to compel. Some courts might bounce you and say, I'm not going to make that decision for you.
Yeah.
This is a joint parent decision and you guys are going to make it yourselves. If you can't do that together, one of you needs to petition for sole decision making. And then you have to do that. Another thing you could try is a status conference, a request for a status conference on issue of mental health therapy for child. Okay, the court will hear that. They're pretty open. They want the kid in therapy, basically. The court does, but they don't want to get appealed either. So the status conference might be a good way to get your matter in front of a judicial officer as fast as possible.
Yeah. And honestly, when it comes to therapy, one of the things that I tell my clients is this is the one specific issue where the courts are almost always going to decide in favor of therapy. The courts, I mean, there's a lot of things that they don't do in the best interest of the child, but I would say 99% of the time, if one parent is requesting therapy, they're going to agree with the parent that's wanting therapy.
It's very low risk for the court. It's very unlikely that something terrible happened because the child talked to a therapist once a week.
Yep. And I want to ask one other question. One of the biggest opportunities that I see for protecting peace and financial stability is putting in an arbitration clause, right? So once you open the can of worms of post-litigation, post-degree litigation, it's a never-ending spiral and it can get really, really expensive. So putting in, some people put in a mediation clause, the parties shall go to mediation before, going to the court to request help. Mediation doesn't have any teeth, right? Mediation requires that you agree to an outcome, but when you put in an arbitration specific clause, can you help us understand how that protects a little bit better?
Yeah, if you're willing to submit to the authority of an arbitrator who is perhaps a former judge, that's who you might typically be going to. If you're willing to kind of forfeit your right to enter the court of law and go to the courthouse and be in front of that judge in the robe, if you're willing to do that, then you can get faster and often cheaper relief by going to an arbitrator. And you can get your decision made with the same amount of teeth you get the court order after you go to arbitration. So you might forfeit just the tiniest bit of judicial sort of like procedural stuff, but ultimately, like Kat said, like you said, at the end of the day, you're usually getting your result faster and cheaper. And it's a way to prevent the other party from abusing the system, essentially, and dragging you to the courthouse in front of the person in the road.
Amazing. Yeah. That's
Great
just
question.
so key, because once you get sucked into the family court system, high conflict individuals are often happy to weaponize the family court system, and
Yeah.
it can be a nightmare.
Yes.
So, one of the things that I did want to point out, ladies, is that you offer free consultations to everybody, which you're one of the very few family law firms that I know that does that. Most family law firms require that you pay the $400-500 an hour for the consult. You offer a free consult. Is that correct?
Yeah, we offer a free initial consultation with anyone who might have some questions about a family law issue. That could be with myself or with Hannah. Completely confidential, like we said, completely complimentary. You have the opportunity to tell us about your situation, ask any questions that you have, and we'll get you some helpful information. And then we do also offer full traditional representation, your typical attorney client situation. But like Hannah mentioned, we also have unbundled services. So you could pay for additional legal strategy sessions with an attorney or an LLP at our hourly rates. Or you could hire us to be basically like a behind the scenes consultant with a small retainer. And then we're just kind of at your beck and call whenever you have a question. So if you'd like to do that, we have our information here on this last slide. The best way to get in touch with us to schedule an appointment is to fill out a contact form on our website or give us a call. And then Kat, we've also got your info on here with your website and your phone number. What would be the best way for people to get in touch with you if they'd like to work with you?
So I offer free consultations to everybody. You can just schedule that directly through my website, ppdcoaching.com. There's a scheduler right there. And so I'm always happy to answer as many questions as I can during that time. Ladies, this is so helpful. I mean, the parenting plan is sort of your roadmap for your entire life.
Definitely.
From the time you're divorced through the time of emancipation, which a lot of people think is 18. It's actually 19. When your kids turn 19, they fully age out of the family court system. And so, this is depending on how old your kids are. If you're divorcing and your kids are very young, this could be a 17, 18-year plan. And then, I did want to honor, there was, Jody asked how to fix the parenting plan. My daughter was taken from me because of coercive control and lying. The court has never accepted any testimony of DV. Jody, I'm so sorry that this is the path that you're navigating right now. I think, that's a tough question to answer in this short amount of time and this space specifically. But, I think one of the things that I wanted to mention is sort of the 3 pillars that I always coach my private clients on. In these cases is the 3 pillars that I base all my cases off of. So that's documentation, neutral third-party testimony, and expert witness testimony. And, we will have a whole different lunch and learn topic to talk about each of those individual aspects.
Awesome.
If you'd like, Jody, I'm happy to have a conversation with you about that. But there's so many different paths you can go. The best idea, like Cierra and Hannah was saying, is to make your parenting plan as future-proof as possible. But know that if something isn't working in your parenting plan, right, you don't know what you don't know. And it's so important to have representation by someone like Hannah, Cierra, myself as a divorce coach, people with experience, especially those living parenting plans, right? People who have lived a parenting plan with a disordered individual like this. We often suggest things that people who are attorneys but haven't been divorced don't suggest, right? Because they haven't experienced the manipulative behavior, the advantageous loopholes that these abusers seem to be so skilled at finding in parenting plans. Even if you think it's airtight, there's always options to go back and change things later. And while it is harder to do that post decree, it is possible. And that's why we really wanted to talk about this today. Ladies, this is it's invaluable advice. And I know it's going to save people so much time and money and heartache. I so appreciate both of you
Yes.
being here today.
Thank you. Thank you so much for having us. And thank you to everyone who took the time to listen. Hopefully we gave you some valuable little tips and tricks, but just know that there is so much more we could talk about. And that if you have an issue that you want to try and tackle with a parenting plan, there's probably a way to do it. And, especially Hannah and myself, that's what we do for a living. We solve complex legal problems and we try and help people. So if we can be of assistance to any of you, please don't hesitate to reach out. And again, thank you so much to Kat.
Oh, it's an honor, ladies. Thank you so much for generously donating your time and your expertise. I will send out a link to the recording of this conversation to everybody who's attended. And the next Lunch and Learn coming up is January 14th. So keep an eye out for an email in your inbox with more information about that. I hope everyone is able to enjoy the holidays. Thank you so much for your time, everyone.